When a child is living with someone who isn't their parent, this person may need to do things that usually only a parent would be able to do, like take the child to the doctor, enroll them in school, apply for benefits for the child, get identification documents like a birth certificate or social security card, or make other important decisions for the child.
How can a non-parent legally do these things? Here are some options.
Number 1, ask the parent to sign an authorization agreement. A parent in Texas can authorize, which means to give permission to, someone else to temporarily make decisions about a child and take care of the child. This is usually done by signing a form called an authorization agreement for voluntary adult caregiver. This is a pretty simple process, and you may not even have to go to court. In many cases, it only requires a notary's signature.
Parents may also sign a document called a power of attorney that gives a caregiver permission to do certain things.
In Child Protective Services cases, a PCSP, or Parent-Child Safety Placement, or safety plan, are documents a parent may be asked to sign when a child goes to live temporarily with someone else so that the child can be safe.
The purpose of all of these documents is basically the same. It's a temporary agreement to help a non-parent take good care of a child when the parent cannot.
It is important to remember that a parent can revoke or take back their permission at any time. It's also important to know that this type of paperwork does not give a non-parent legal custody. Only a court order can do that.
Number 2, go to court. A non-parent can sometimes file a court case to get managing conservatorship or custody of a child. To file this kind of lawsuit, the non-parent has to have standing. Standing means that you have the legal right to go to court about this child.
There are many ways for a non-parent to have standing in Texas, but some common ones are someone who has been the primary caregiver of a child for at least 6 months, or a close relative who needs to protect a child from an unsafe situation.
Many relatives want to know if they can be part of a custody case that's already going on, especially when it involves CPS. This is sometimes possible. It's called an intervention. But again, you have to have standing. You have to file a petition in intervention, and sometimes a judge has to give special permission.
What about if you've been taking care of a child for a while and now the parent says you have to give the child back?
A parent gets to decide where their child lives, and they can take the child back unless there's a court order that says something different. But if you are worried about the child's safety, watch our video on child safety issues.
If a parent requests a writ of habeas corpus, which asks the court to make you give the child back, a response can be filed explaining to the judge why that would not be safe.
And what about grandparents' rights? Can a grandparent get the right to see a grandchild if the parent doesn't want them to?
In most cases, no, not in Texas. This decision is up to the parents. But there are a few exceptions to that rule if the parent is not able to let you see the child, for example, because they're incarcerated or deceased. TexasLawHelp.org has links to information and self-help legal guides for authorization agreements, original SAPSers for a non-parent, modifications, interventions in a CPS case, responding to a petition for a writ of habeas corpus, and child visitation by non-parents.
Have any other questions? Chat with us at the link below.